Test, test. Good morning, ladies and gentlemen. Our first case for argument this morning is East St. Louis against Netflix. Ms. Sims.
Your Honors, good morning, Council. It's a privilege to be here today. Thank you for agreeing to have our oral arguments. As you'll see, this is a very important case. Not only have we filed this lawsuit, but there have been numerous other lawsuits filed throughout the country. I am here representing the City of East St. Louis in its capacity individually, but also as class representative for other similarly situated municipalities and local governments in Illinois. At the heart of this case lies a simple but profound question.
Before we get into the merits, Ms. Sims, we need to discuss subject matter jurisdiction. And I wonder why there is any.
So we sued under diversity for the defendants, of course.
Well, that isn't that the problem? You have defendants which are extraordinarily complex entities that have many layers of organization. And there's one in particular that I'm worried about, which is AT&T Capital Services, which turns out to be the 7th level owner of Warner Media Direct. Okay. AT&T Capital Services appears to have its principal place of business in Illinois. Okay. And then there's no diversity jurisdiction. That's the problem, or that's the most serious problem.
At the time we filed, I don't believe we were aware of that situation.
It's clear you weren't aware of it, but the question is not whether you were aware of it, but whether it's true.
Well, it appears that it is.
Well, so you agree that it is?
It appears that it is, yes.
Then why are we here? If you believe that indeed you have sued somebody from Illinois, then there is no diversity jurisdiction, and your ethical obligation is to dismiss this suit. If that's what you believe.
That is well taken, yes.
Then why are we here?
I guess I don't have an answer for that. I appreciate the question.
Your brief asserts that there is complete diversity. So are you now telling me that you made a knowingly false assertion?
No, I believe at that point in time, Your Honor, when we filed our brief, there was a request upon the defendants, request upon us to supplement that information. We inquired of the defendants that information, they provided to us, and we supplemented it after we filed the brief with this court.
If you believe there is no diversity, then what else is there to do?
If that change in the ownership happened.
There's no change in ownership that we can tell. Diversity, jurisdiction depends on the matters on the day the complaint is filed.
Yes.
So far as I can tell, there's been no change afterward, and no change would count. But there may be an increase in knowledge, because it looks like your client filed this lawsuit believing that jurisdiction was supported by the Class Action Fairness Act. And not having done any research, you or your client didn't find Section 1332D4, which says that the Class Action Fairness Act does not provide jurisdiction in cases like this. And so the fallback is diversity of citizenship. And as I say, if you agree that AT&T Capital Services has its principal place of business in Illinois, we're all done here. And I take it that you are now agreeing that that's true. Needless to say, I will ask Mr. Garay whether he agrees that that's true, because his brief also asserts that there's complete diversity.
Would you like me to defer to counsel for the question or proceed?
Well, you're here. If you want to try to argue the merits in the case something is miraculous, please go ahead. But If you agree that there's no diversity of citizenship, it's hard to see where we can go.
Well, if I may, Your Honor, if I could reserve the rest of my time?
No, you can't reserve the rest of your time. The rest of your time is rebuttal time, right? If you want to make any argument on the merits, now is your only time.
Your Honor, I apologize for the issue about subject matter jurisdiction. I would like to proceed on the remaining issues for the court. This case arises from the corporate behavior of streaming companies who have deprived local governments from the routine revenues owed in exchange for use of their public resources. Now, the district court dismissed our 5-count cause of action with the utmost respect to that lower court. We believe it was an error. The district court erred when it ruled that the city did not have a right of action to seek the 5% gross when it properly alleged that the streaming companies used private content delivery networks located either connected to or within the local internet service providers and which are located within the public rights-of-ways. The district court erred also when it concluded that the city did not allege that the streaming companies have trespassed on the city's rights-of-ways, dismissing our trespass and unjust enrichment counts. Even though the complaint states that the streaming companies utilize private content delivery networks in the local rights-of-ways as a way to stream their products. The district court erred when it dismissed the city's claim based on an ordinance on its face prohibits the resale of cable communication. And we ask this court to consider the broader implications of allowing streaming companies to operate unchecked and unaccountable to local communities. We believe that a proper application of the law will affirm the rights of cities like East St. Louis, ensuring that they are not marginalized by the business interest of these streaming company giants. To avoid compensating municipalities for the use of their infrastructure, the streaming companies have leveraged private interconnection agreements with cable providers to house their video content on servers located within the ISPs, and that's in the amended complaint, paragraphs 35 to 69. Netflix terms these servers open connect appliances. Appliances would indicate that it is an actual physical piece of equipment. That's in the amended complaint, paragraph 43. Netflix alone has placed nearly 1,000 of these servers in the United States, many of which are directly connected to the ISPs. So there is equipment either in the rights-of-ways or connected thereto. Remarkably, these companies elude both state and federal oversight, but look to wield those same statutes as a shield against these local government rights.
On the express right of action,
Yes.
in the using language, using it as a shield, can you tell me where in the record did we raise the argument regarding section 901?
901 of the Federal Cable Act,
Of the Illinois statute.
of the Illinois statute.
The defense argued, as you may recall, that you forfeited any such argument.
Yes, yes. Well, the express right of action, okay, for purposes of this argument here today, I think has been
The
somewhat
question
resolved.
was whether you raised the 901 point in the district court.
No.
Okay. Why isn't that a forfeiture?
Well, the express right of action, we believe, is, against the weight of the other cases, it's not our best argument. Our best argument is the implied right of action.
So
Given that, go ahead.
I'm sorry.
Go ahead. Sorry.
So how do we agree that section 901 argument was forfeited?
Yes.
And so you didn't contest the section 1301 expressed, and so are we agreeing that that has been waived?
Yes.
All right, so we're moving only to the implied right of
Yes.
action?
Yes. For purposes of the argument today, I had prepared to just talk about the implied right of action.
I want to be clear, though, that you agree that the section 901 argument has been forfeited.
Yes.
Okay, so we are just focusing on the implied right of action?
Yes.
Okay.
Yes.
The fact, though, that the statute does create a right of action under 901
Right.
seems to weigh against finding a separate implied right of action, right? That is, the legislature
Yes.
said, here's something that local governments can do.
Well, but it was very ambiguous. That express right of action, we believe, was ambiguous as to this action brought before this court regarding the auditing of the defendant's 5%. We're not seeking that they apply or receive their holder's license, unlike all the other cases that have been filed. We're not seeking that. We're not asking that they stop their services. We're not asking that they reapply for their holder's certificate or apply
Are you
for one.
asking that they all place customer service facilities within each local government boundary?
We believe, based upon the public available information and the business model of the streaming companies, that in order to stream their content, they have to place these servers or private content delivery appliances on or
That's not my
connected
question.
to.
My question is about the point that the defense made under 22-501, I believe it's B3, that cable or video providers shall maintain a customer service facility within the boundaries of a local unit, staffed by a customer service representative, et cetera. You saw the argument.
Yes,
Are they reading the statute correctly?
yes.
That if they are deemed providers, then anybody that you think is a video service provider has to open up a storefront in East St. Louis. Is that right?
If they are a holder under the state statute, yes.
Would that, so any streaming company, Illinois has 2,000 municipalities? Something,
Yes,
that they're gonna have to, as you read the statute, then every one of them has to open up a separate customer service facility, brick and mortar facility in every one of those municipalities they serve.
if they are granted a holder's license, they would have to do
But
that.
you're saying they
yes.
have to have a holder's license
That's
to do what they're doing, right?
That's what the statute says, yes.
Doesn't that strike you as kind of an odd result?
Well, no, not when they have equipment in the rights of ways. If they have equipment in the rights of ways, such as these appliance and servers, then they should be responsible and have somebody local to talk about if something were to happen to that equipment. They should have a local person to address those issues with the city.
How many video service providers do you think, who qualifies? We have the big players here as defendants, right?
Right.
How about a network that produces video content and then arranges to have it streamed?
If they use the local rights of ways,
Well,
need to
ultimately,
do
the
that.
streaming would happen. So like NBC and ABC and how about, let's say, the producers of Yellowstone, popular series streamed for lots of people all over the country. Are they, that's streamed through all these facilities you're talking about, are they video service providers as you see it?
that the Paramount is that.
Okay,
has-
so Paramount has to open up 2,000 storefronts in Illinois if they want to stream Yellowstone?
The statute requires that.
Okay. Could I also ask you?
What's your
Go ahead.
what's your best Illinois case for that proposition?
That they would have to provide that? That,
Yeah, we can take that proposition, or for the proposition that they are holders.
that they are holders is that they are using.
No, I asked you, what is your best Illinois case for that proposition?
We don't have any.
You don't have an
cases for
Illinois
that
case.
No.
That's a separate problem. You're asking us to create what is, I think, a very large innovation in Illinois law. And it's a pretty fundamental principle that if you want an innovation in state law, you need to go to state court. It comes back to my question, why are we here? I'm sorry, I didn't mean to interrupt.
No, I just, well, let me, if I can circle back to the jurisdictional question though for a second. And maybe I missed something, but I'm looking at the amended jurisdictional statement that says AT&T Capital Services is a Delaware corporation with its principal place of business in Texas. Was that updated?
I would defer, I received that directly from the streaming company, so I would defer to their
Okay.
information.
Could I ask you about your trespass theory?
Yes, yeah, so,
The defense has brought up a line of cases in which, at least as I understand it in Illinois, if a tenant is exercising a leasehold in ways that violate the lease, let's say they're holding parties and charging admission for them,
yes,
the tenant's guests are there with the permission of the tenant. there might be a breach of contract between landlord and tenant, but the guests of the tenant are not trespassers. That, I didn't see a response from you about that
Yeah.
theory.
They are not tenants.
Oh.
The cable operator is a holder under the statute, akin to a license, okay? So they have no authority.
But we're agreeing that the internet service provider is a holder under the interpretation. What we're asking though, why would the guest, using Judge Hamilton's example, why would the guest
The
be
guest.
trespassing?
Yes, the
in
guest
this
has a physical piece of equipment, the server, that they have connected to the rights of ways. And pursuant to the statute, the only party that can access that rights of way is a successor to the holder of that license. So they're
Who
not.
owns the wireline facilities that exist in the public right of way?
The wireline facilities are owned by different cable operators throughout the state.
And so what would suggest, I'm trying to follow the trespass argument, that there are any type of physical facilities intruding upon the public right of way from those streaming companies?
The city owns the public right of way, which is land on either side of the road. In order to access that, the cable operators, the owners of the internet service provider lines, they have to get permission from the state and the city. They are holders, they are licensed.
Correct.
Okay, they are not tenants, unlike an easement. They do not have an easement, they have a license.
Okay.
Okay, we have the easement, the city has the easement. So they are not a tenant of that piece of property. They don't have the ability to assign or have a successor in interest for access to their lines that are located within our easements without permission from the Illinois Commerce Commission.
Does the landowner get to dictate to the renter what guest he can have?
Well, in the statute, the successor in interest has to apply to the Illinois Commerce Commission and has to notify the city if they're going to be a successor to the party that has the ISP, the wireline facilities.
So there's no infrastructure that's being used by the streaming companies in the public right of way?
Well, they are accessing it, they are using
That's not
their.
my question. Is there any intrusion by the streaming companies into the public right of way?
We don't know the terms of the interconnection agreements. Those remain private.
Why do you need the interconnection agreement to know that? Why don't you just
Well,
observe the public rights of way in East St. Louis?
we don't know if there are servers connected or within those rights of ways.
I don't know why that's an intrusion. Let me ask what seems to me the same question in a different way. Suppose what's passing over a line is not information, but electricity, right? It's another thing you can do with electrons. You have utility poles, either above ground or buried in East St. Louis. And the electric company, probably Exelon, needs a permit from the city to build and maintain those poles. But Exelon then buys energy from third parties. Indeed, energy is wheeled all around the country. It buys energy from third parties and delivers it to homes in East St. Louis. Does the energy provider need the permission of the city of East St. Louis?
No.
No. So why is it any different? I just gave you an example with wires on the public way that transmit electrons. That's what Netflix is doing. Those wires on the public way are transmitting electrons. Why is the answer to the two questions any different?
Because these streaming companies have physical appliances. They're called open appliance networks. They're called, with Netflix, they're able to have computers, servers, either within the ISPs, according to their own releases, or connected to. So they have a server that is connected to those wire lines.
I don't think you understand either how Netflix works or how electricity is wheeled across networks.
Ms. Sims, could I ask you to address the effect of House Bill 3808 enacted earlier this year?
Yes. It's not effective until January 2024, and we don't know the retroactive effect of that. We don't know whether it is substantive or procedural.
Substantive or procedural?
Well, there are parts of the act that talk about definition of service, basic service. We don't know whether it applies to a pending case or not under Illinois law.
Well, ordinarily we think of statutory amendments as being either clarifying or amendatory. Can you point us to any indications you have that this changed the meaning of Illinois' law as opposed to merely clarifying?
It changed the meaning of the service, the service.
Why?
Cable
Why do you
service.
say that?
The actual act changed the meaning of what cable service is.
My question is, how do we help us understand why we should treat that as substantively changing the scope of Illinois law as opposed to merely clarifying the issue before us here?
So, I'm out of time, if that's okay.
As long as we're asking questions, you can keep giving answers.
Thank you. So the actual amendment that deals with what a definition of cable service is changes the landscape because technology is constantly evolving here. So because it's constantly evolving, we don't know, we can't tell into the future what is happening with these cable communications. So what's happening is, I'm sorry. The definition of cable service drastically changes the effect of the statute. It's not a procedural matter.
I'll take that as your answer. Thank you.
Okay, thank you, counsel. Mr. Garay. You know where we need to start.
Yes, Your Honor. Thank you, Judge Easterbrook, and may it please the court. So our understanding is that there is subject matter jurisdiction. One, we did acknowledge in our brief that we believe that the amended jurisdictional statement was correct, and that was based on our understanding. We haven't gone back to drill down.
Well, that's the problem, though. The amended jurisdictional statement says that AT&T Capital Services, Inc. has its principal place of business in Texas.
Right.
Right? And Ms. Sims said on her feet that she got that information from you or your clients. The problem is, if you look at AT&T Capital Services' own website, it lists its headquarters as Illinois. There's some question whether it's in Park Ridge or in Chicago. They list both addresses. LinkedIn lists the addresses of both the president and the CFO as Illinois, and so on. That certainly gives rise to a belief that its principal place of business is in Illinois.
Right.
And that's a problem.
Right. So let me first apologize for not having drilled down to this level. Second, I would suggest that because this court's jurisdiction is conceivably affected, that we would confirm that and provide additional information to the court on that. I do think, though, that there's a legal answer as well. Under our understanding of CAFA, you wouldn't actually...
No, if you used real words, that would help.
Okay. With respect to CAFA?
No, if you use real words, CAFA is not a real word.
Got it.
If you look it up in the dictionary, it is not a word.
The Class Action Fairness Act, Your Honor. If you look at the Class Action Fairness Act, I think in 1332 D10, our understanding...
I'm interested in D4.
Okay.
D4 says that a district court shall dismiss any case in which more than 2/3 of the class is in the same state as the defendants and so on. This class, by definition, is an all-Illinois class. It is resting exclusively on Illinois law. Now, if you have some answer to the problem under D4, I'd appreciate it, but
I do, Your Honor. So under D10, we think that that puts the focus on the defendant itself, Warner Media, and wouldn't require you to drill down to the level of AT&T data.
No. Minimal diversity is established. D4 is a completely different problem.
Right. I mean, we would love the opportunity to provide a supplemental brief on this, Your Honor. We do
It's
think
clear
that
we are going to need supplemental submissions
Yes.
on jurisdiction.
Appreciate that, Your Honor. With respect to the issues that have been briefed on the question of the private right of action, I think as my friend conceded, their argument before this court based on Section 901 of the Illinois statute has been forfeited. In the court below, as the district court acknowledged on page 8 of its decision, the city's argument was based on Section 1301 of the Illinois statute. It's no longer making that argument before this court. Instead, it shifted to Section 901 of the statute and the provision that allows cities to audit the holders of an authorization. That argument is forfeited and it fails on its own terms because obviously none of the defendants here are currently holders of an authorization. There's been no audit, and so there's no conceivable basis for the city to maintain an action under Section 901 itself. There also is no basis for this court to take the extreme step of inferring a private right of action under any other provision of the Illinois statute. Courts across the country, although not binding on this court, have reached the same conclusion in almost identical circumstances, and there's no reason for this court to break from that pack and find any implied basis for the city to maintain this action under the Illinois statute. With respect to the common law claims, it's conceded that both the trespass claim and the unjust enrichment claim rise or fall together. And I think the trespass claim fails for the reasons that Your Honors exposed during my friend's topside argument. I think I want to correct one possible misimpression, though. The streaming defendants here do not install or maintain or construct any facilities on the public rights of way. In fact, the complaint at paragraph 60 acknowledges that, as did the city in its brief on page 21.
As I said, I had my doubts that Ms. Sims accurately understands what a server is and where servers are located.
Right. And those...
They're not attached to cables.
That's exactly right, Your Honor. And the servers on which they have attempted to shift the focus involving the Netflix's Open Connect network are all located on private facilities. And in fact, they acknowledge that themselves in their complaint. For example, paragraphs 43 and 44 acknowledge that these servers, which are simply like a server you might have underneath a desktop computer, relatively small in size, are located on the ISP's private network facilities. I think, ultimately when you take a step back and you look at what's going on here, I think it's important to appreciate that all the streaming defendants are doing is making content available for individuals to access through their own devices and through their own ISPs over the internet. This has nothing to do with the defendants actually constructing, installing, or maintaining anything on wire lines in the public rights of way, which is the prerequisite for imposing this franchise fee on anyone. And that's why the trespass claim fails at all as well. There is no physical invasion whatsoever with respect to the city's own property by the defendants for the reasons that they had nothing to do directly with the public rights of the way, for the reasons that Judge Easterbrook acknowledged or noted with respect to the electronic transmission of data over the internet, which doesn't have any physical component. The claim...
Well, electrons are physical. They're just not very big.
That's right, Your Honor. And I think it doesn't, that no court has ever recognized that is a physical invasion. It's certainly not an unauthorized physical invasion here because defendants make their content available through the ISPs, and that ISPs have authorized the use of that. I'm
I
sorry, Your
didn't
Honor.
hear any argument this morning regarding the city. They had raised about the right to enforce its own ordinance. And so, do you agree that the city would have the right to enforce its ordinance? It's not limited to the Regulatory Affairs Court?
No, Your Honor. So if you look at the terms of the ordinance itself, it allows the city, purports to give the city the right to enforce that in administrative court, the Regulatory Affairs Court, or in certain instances in criminal proceedings. The city's own ordinance doesn't give it the right to pursue a civil action like this, and so that the claim would fail for that reason alone, as the district court concluded. So we think the ordinance claim fails as well.
Why couldn't the city just go to court to get an injunction to require compliance with the ordinance? Not to impose sanctions or penalties, but simply to require compliance.
I think it would need a private right. It would need a right of action, Your Honor.
It's the lawgiver, right?
I'm sorry, Your Honor, I missed it.
The city in that case is the lawmaker, the lawgiver.
I suppose, Your Honor, could pass a new ordinance and purport to give it that authority. It hasn't under 8219, which is the ordinance in effect now. If you shift it to the declaratory judgment context, for example, seeking a declaration, it's clear that they would need a independent substantive right of action in that instance. They haven't pointed to any substantive right of action to maintain that ordinance, whether seeking an injunction or any other enforcement action in this court.
I would have thought that was kind of assumed. Just for example, I don't believe there's any provision in the United States Constitution that I know of that expressly authorizes granting an injunction to enforce its terms, right?
I don't believe in the Constitution, Your Honor, but I think you need the right of action to go into federal court to seek relief, whether it's injunctive or
federal
declaratory.
court, we have limited jurisdiction, et cetera.
Right.
But in state courts, I would have thought if a state simply announces this is the law, the state government could, at a minimum, seek injunctive relief to require compliance with it.
So, Your Honor, I apologize. I mistook your question as referring to this action in federal court. In terms of whether they could go to state court and seek to enforce the ordinance, I don't believe that they could, but I think that would be a different question.
But didn't the district court find that? I'm sorry.
No, but if you have if the district court here is in essence standing because there may or let's assume there's sufficient diversity,
Right.
But then the district court is standing in the shoes of the state court.
I don't believe it could, Your Honor. I think the same flaws with its private right of action argument would apply here. I think you would look first, the federal court would look first to the terms of the ordinance, and that ordinance provides very specific means by which it could be enforced, none of which are applicable here, and I think that would resolve the question as the district court concluded.
When you look at the East St. Louis Code of Ordinances for the city itself, section 2-252, it says the mayor and its officials can enforce its ordinance under this regulatory affairs or by any other means. So why would the injunction route that Judge Hamilton suggested be permissible?
I think the language in 8219, which is the more specific provision that they've invoked, would apply here, Your Honor. I also don't think that the city has made an argument under that particular provision. It certainly wasn't made below my understanding, Your Honor, so I think that any claim based on that construction would be forfeited.
Mr. Gray, I want to come back to the jurisdictional question. I wasn't fast enough on the uptake when you referred to D10. I take it you were linking back through, I hate stuff like this, through D4A1 Romanet 2 paren CC close paren. And maybe that's exactly right. I hadn't tried to go through that chain before, but I would like both sides to address whether D4A1 Romanet 2 CC in conjunction with 10 means that the Class Action Fairness Act does provide jurisdiction here.
Yes, Your Honor, we would happily do that. Thank you, Your Honor. I reserve my time, or not reserve my time, and my time unless the court has any further questions, and Mr. Michalopoulos, please present an argument.
Thank you,
Your Honor.
counsel. Mr. Michalopoulos.
May it please the court, Pantelis Mikalopoulos for this. Even if the city could squeeze past the courtroom's door, despite the presentation by Mr. Gar, they would not go far because of their failure to state a claim under the Illinois law and in light of the controlling precedent in this circuit of City of Chicago. And so this law is all about facilities-based providers. It mentions facilities-based providers twice in the introductory provision, section 101. And those are the phone companies and the cable companies that need to construct facilities in the public rights-of-way. They are not the defendants who do neither. Now, what does the city do to cure that disconnect? It uses the innocuous-sounding words or linked to. In other words, for the law to apply, it is enough if some streaming video equipment is linked to the facilities of the telephone company, which in turn use the public rights-of-way. But as Judge Beatty correctly remarked in rejecting the trespass claim, this will bring in the entire world. It will make the city of East St. Louis into an internet policeman, because the New York Times, the Chicago Tribune, CNN are no different than Netflix or Dish. They provide streamed video and they derive revenue from it, whether it's subscription revenue or advertising revenue. And so according to the city, if a Netflix customer wanted a movie who lives in East St. Louis and asked his phone company to transmit that movie, along the cornucopia, the trillions of bits that make up the public internet, that transmission by the phone company would suddenly become a use by Netflix. But if I fly Delta to go to St. Louis and I want to visit a relative in East St. Louis, I take a taxi. Now, the taxi will drive in East St. Louis roads for the last leg of the commute, but this cannot mean that United Airlines or Delta has used East St. Louis's public rights-of-way. And that's why so many courts have rejected this concept of use. In the words of one federal district court in AT&T versus Dallas, it's a metaphysical concept. And the Supreme Courts of Ohio and Tennessee have weighed in, many other courts. But this court has decided City of Chicago, where it said, it is incontrovertible that in some historical and important sense of the word, it is reasonable to conclude that a non-facilities-based provider, ECI, who was leasing a strand of fiber from the telephone company, then Ameritech, has not used the public rights-of-way. And in fact, the court went further and said, because this was a case coming up from the FCC, and I hope Judge Easterbrook, FCC does not offend your preference for actual words, it said, we are confident that even if we were making the initial determination, we would reach the same conclusion. And even the dissent of Judge Rovner, on which the city relies, would not apply here, because Judge Rovner was concerned about too much weight being assigned by the majority to the distinction between owning a strand of fire and leasing it. But here there's no leasing either. The video is part of the trillions of bits that make up the public internet. No private lines. And by the way, the complaint is based on most defendants on allegations made about only one defendant. It's only one defendant that has an interconnection agreement, not a lease agreement. It's only one defendant that places video in a server that's located near or in the phone company's offices, as if the office of the telephone company was located in the public rights-of-way, something that is not asserted. But in any event, all of those allegations are made about one company. And
Mr. Michaelopoulos, you all urged us to consider affirming on that ground that the complaint insufficiently identified the role of each defendant. And my question is whether that would really be appropriate, since that is ordinarily such a fixable kind of problem. I would find it difficult to reach that conclusion for the first time on appeal and say that a dismissal with prejudice should be affirmed without giving an opportunity to amend.
I understand, Judge Hamilton, but there clearly is no good faith basis on which to make those allegations about the other defendants, and the court can take.
Well, I don't know if I know that.
Yeah, but there are
You
several.
have other arguments. I'm simply discouraging you from pursuing this alternative ground for affirmance.
Yes, I understand. I mean, the record is not replete, but does contain references to those peering agreements by which most video passes alongside the public internet, and there's no need for any specific interconnection agreement between the streaming provider and the phone company or the cable company. But I understand your point. And let me just say one thing about the ordinance, the colloquy that we had with Mr. Gar. The idea is unauthorized resale of cable service. But this is totally apples and oranges. We're not talking about resale of cable service here. In fact, what the city's position is that what our clients are providing is something distinct from cable service, video service. So how can there be an unauthorized resale of cable service? And finally, the city is talking about protecting the city, but it's not really talking about protecting the city's residents, because it is they who would bear the brunt of the fee. The Sixth Circuit in Eugene, the FCC, has said, of course, those fees are passed through, and this law contains a specific contemplation of the pass-through. And so, far from lining the pockets
Thank
of
you, counsel.
All right, thank you.
The case is taken under advisement. We'll hear argument now in Patterson against Howe. Mr. Murray.
Good morning. May it please the court. I'm here on behalf of the appellant defendant, Howard Howe, and this is a Fair Debt Collection Practices Act case. Mr. Howe is a collection attorney, and in May of 2016, he filed a collection action against the appellee plaintiff, in this case, Mark Patterson. That case, the collection action was to seek repayment of tuition fees that were owed to Indiana Technology, Institute of Technology. While the collection action was still pending in state court, Mr. Patterson filed this Fair Debt Collection Practices Act case in federal court in December of 2016. Excuse me. Mr. Patterson alleges that Mr. Howe engaged in deceptive and misleading misrepresentations or used unfair and unconscionable means under the Fair Debt Collection Practices Act because he served requests for admission on Mr. Patterson at the same time that he served the complaint in the collection action. The collection action, meanwhile, went to mediation in April.
The district court found that that was a substantive violation of the federal statute. Your brief purports to contest that in one paragraph at page 65, containing no citations and no argument. Do you think it's fair to say that you have forfeited that contention on appeal?
No, Your Honor, because the substantive issue overlaps so much with the jurisdictional issue.
I don't think so. What the act requires and whether somebody was harmed are distinct questions.
If we respectfully believe that the jurisdictional issue involves questions concerning whether Mr. Patterson was harmed, obviously, by the
Yes.
practice. And if there was no harm, and if the practice itself was not likely to cause harm in these circumstances, it also would not be an unconscionable or misrepresentative or other means under the FDCPA.
I think you will find at least one member of this panel is very reluctant to go backward from no harm, therefore no violation. We have quite a number of cases in this circuit saying we assume a violation, but the plaintiff does not have subject matter jurisdiction because there was no harm. As I say, we'd be very reluctant to kind of run that tape backward and say no harm, therefore no foul. This isn't football. There is absolutely no argument in the merits section of your brief. None. Not a whit.
We do refer back to the McCullough decision, Your Honor, which is discussed, it is discussed in relation to the jurisdictional issue, but it also goes, that is the sole case that the district court relied on for the substantive finding of an FDCPA violation, the McCullough decision from the Ninth Circuit. And in that case, the court found that there was an FDCPA and Fair Debt Collection Practices Act violation because the request for admission served in that case asked the defendant, the pro se defendant, to admit facts that were untrue, which would have forfeited the collection action defendant's statute of limitations defense.
I must say, your statement that this section of the brief refers to the Ninth Circuit case and discusses it does not accord with your brief, which I'm staring at. It is one paragraph, there are no citations, and there's no argument. It doesn't refer to anything.
Your Honor, we did not include a cross citation to that part of the brief in our opening brief, but we do in our reply brief, which
The usual word about reply briefs is too late. You have to make your argument in your opening brief.
yes, Your Honor. With respect to the jurisdictional issue, which would dispose of this case obviously entirely, there are two issues with the district court's decision. The first being that the harm that the district court relied on occurred 4 months after the Fair Debt Collection Practices Act complaint was filed. That fact did not even become known or part of the record until about 4.5 years into the case.
Would you agree that under the law of this circuit at the time the complaint was filed, however, there was standing?
No, Your Honor. In Mr. Howe's summary judgment briefing, he cited Spokio. He relied on the case that this court subsequently relied on in Casillas. Apologize if I mispronounced that.
You're unwilling to acknowledge that there in essence was a revolution in this court's FDCPA standing jurisprudence starting in the last couple of months of 2020?
There were obviously an avalanche of cases after this case was filed.
To put it mildly.
Yes, Your Honor.
And along those lines, you've been very critical of plaintiffs' effort to, in essence, fix the standing problem, as you see it, right?
There have been procedural issues we raised objections to, Your Honor.
And I guess my question is, given the dramatic changes in this court's jurisprudence on this question, why would it be at all unfair to allow parties to, in essence, respond to new questions and changes in the law with additional evidence and or allegations?
Well, I'd like to focus on what specifically happened here, and that was that the plaintiff, Mr. Patterson, stipulated to summary judgment based on the allegations.
Let's assume that it took him 4 years. Judge Hamilton's question is one I share. What's the problem with fixing it later? There's a statute which the parties don't refer to. The statute is 28 U.S.C. 1653, which says that jurisdictional allegations may be amended at any time in the litigation, even in the Court of Appeals. Well, doesn't that just completely undercut any argument that it was too late to amend jurisdictional allegations?
How he amended it was to add an assertion, and if you assume that the deposition was an amendment, how he amended it was to add a claim that the harm or the injury in fact
Right,
occurred 4 months after the.
No, it's a different problem whether the amendment was adequate from whether the amendment was in time. Section 1653 tells us it is never too late to amend your jurisdictional allegations. Now, we can discuss whether the jurisdictional allegations are adequate, but it's never too late to amend them. That's what the statute says.
Certainly in the district court, and so far to date in this court, there has been no formal motion for an amendment of the jurisdictional allegations. But I
It
understand.
can be amended today, right here. That's what the statute says. Drop this line. You want to argue whether there was real harm.
Yes, Your Honor. And that, I think, obviously disposes of the case, irrespective of the other issues, Your Honor. And that is, first of all, as I noted, the injury, the only precise injury that was ever identified by Mr. Patterson was this alleged allegation that he lacked leverage at the mediation that occurred 4 months after the Fair Debt Collection Practices Act complaint was filed. That is insufficient to retroactively create jurisdiction.
Is that reframing, though, what he has identified both at the deposition and in the order there, where it characterizes the deposition? Having reviewed that, wasn't the argument, though, the loss of a legal defense?
He has never identified any specific defense that he lost, Your Honor. And that's what distinguishes this case from the plethora of cases that talk about statute of limitations, for example, defenses being, or zombie cases being revived. Here, Mr. Patterson never put a name on any defense that he alleged he had to the collection action complaint. That is, he never said that it was beyond the statute of
No,
limitations.
he filed an answer that said, in essence, this all happened because the university screwed up, right? They gave him bad information. He filed an answer denying the claim, right?
He filed an answer denying the claim, Your Honor, yes.
So clearly he may have been right, may have been wrong. Ultimately, that was settled, right?
It was, Your Honor.
Okay, I guess I have two questions. One, why on earth did that get settled without resolving the pending Fair Debt Collection Practices Act claim at the same time? I can't imagine that happening, but here we are. And second, what is your how would it affect your standing argument if the plaintiff had waited until a month after the mediation resulted in the settlement of the state case to file this claim?
That gets to the second reason why we contend that the issue that the court focused on is insufficient to create an injury in fact. And that is, it's an entirely subjective issue, this leverage. And the belief that he lacked leverage, and that's why we have focused somewhat on what were the merits defenses.
Okay.
How does
Can we go back for a second though?
Yes, Your Honor.
How is this not resolved in the settlement of the collection case?
That's an interesting question because Mr. Patterson, although he was represented by counsel in the Fair Debt Collection Practices Act, continued to be pro se in the collections action.
Mr. Howe, however, was the defendant in the pending case, and he didn't get a release?
I was not involved, Your Honor. There's no release that I'm aware of, Your Honor. I would like to reserve some time for rebuttal, but I'm happy to address further questions now if the court would like.
I don't see any at the moment.
All right, thank you.
Thank you, Mr. Murray. Mr. Duff.
If it please the court, my name is Robert Duff. I represent the plaintiff appellee, Mark Patterson. I want to start out this morning by apologizing to the court for perhaps some confusion or complexity that's been added to the standing analysis or inquiry here as a result of the plaintiff coming forward with evidence that the request for admissions hurt him in the state court case. That was done out of an abundance of caution, but we do not believe that evidence is necessary to establish standing under this court's precedent. under this court's precedent, that evidence was unnecessary, and all that was necessary was to show that the plaintiff, Mr. Patterson, would have done something different if he, absent the violation, or if he had been provided the information that would have avoided the violation.
Mr. Duff, why didn't you tell Mr. Patterson that he could simply seek to withdraw the effects of the request for admissions, particularly given his simultaneous, his timely answer denying the claim?
I didn't represent him in the state court debt case. Made that very clear. That was documented in our representation agreement, and
So
we
you
had
just
that
left him
understanding.
to sink or swim in the state case and then pursue the federal remedy?
You could put it like that, Judge.
I just did. I am mystified by this case. I'm mystified that Mr. Howe didn't get a release when the state collection claim was settled, and I'm mystified that you didn't tell Mr. Patterson that these the requests for admissions should have been easily set aside under those circumstances.
Mr. Howe didn't get a release because the settlement, so-called settlement, was a agreed judgment that got filed with the court. So there was no.
Now,
If
there
it's
was-
agreed, it can be agreed with a release.
You know,
And so just so I'm clear, reviewing the record, the representation was made by Mr. Patterson that you advised him that the admissions were deemed admitted now that you failed to respond. And that's what was represented in the record. Is that incorrect because we use the sink or swim language?
no, I believe that is correct.
You did advise him that they were deemed admitted.
But yes.
Okay.
But it was in the context of the inquiry into the FDCPA violation related to that case. And I understand how that could be partly mystifying, but that in fact was just what happened. It was he handled the state court case, and I represented him in the FDCPA case, and there was not a lot of overlap.
So let me try to put the question this way, Mr. Duff. When do you contend Mr. Patterson suffered an injury in fact in this case?
We contend that he suffered the injury in fact when he did not timely respond and the admissions were deemed admitted as a matter of law under Indiana law. And we believe that that is sufficient, and that the LaValle versus Med 1 case is controlling here and essentially is on all fours with that. Let me explain. In the LaValle case, the consumer had a right to receive a validation notice from the debt collector and be informed how to dispute the debt. And she did not receive that validation notice. The court there concluded, in looking at standing, that it was reasonable to infer that had she received that notice, that she would have disputed, and that would have stopped the collection action temporarily while the debt collector obtained verification and provided that to her. And there was no further requirement in the court's analysis that dispute that she would have made would help her or alter the case in any way. It was just simply the fact that she would have made a different decision if she had been given the information that she was entitled to. The same thing occurred here. Mr. Patterson was entitled to be informed that these requests for admissions would be deemed admitted if he didn't respond to them
Why?
in 30 days.
Does any rule of state practice require that?
No,
Don't you think it's bizarre to say that some federal statute requires a plaintiff in state court to notify the adversary about rules of state procedure?
No, I don't. This is a consumer protection statute, and it's not that does not have to occur if you're dealing with
Have
an
we
attorney.
ever held that the act requires that? Has any court of appeals ever held that the federal statute requires the plaintiff in state court to notify the defendant in state court about how state rules of procedure operate in state court?
There are requirements that
No,
a debt
I asked
collector.
a question whether particular cases have so held.
Yes,
Do you know of such a case?
I believe so. I believe the court has said that if a debt collector is collecting a debt that's outside the statute of limitations under state law, that the debt collector in certain situations has to inform the consumer that the debt that it's past the statute of limitations, and the consumer, if they do certain things.
I wish you'd address my question. Has a federal court held that the plaintiff suing in state court must inform the defendant about a state rule of procedure in the litigation? The statute of
know.
limitations is not a rule of procedure. I looked to see if I could find such a case, completely unhelped by Mr. Murray's citation-free argument section. Didn't find it.
I can't
should
put my
think
finger on
it's a
one.
pretty big step to say that the Fair Debt Collection Practices Act now regulates notice about state rules of procedure. I don't think we're going to have an occasion to tackle that here, given the lack of argument from the appellant, but it's a potentially important question.
I understand, Your Honor. So we believe that the Patterson case here is on all fours with LaValle, and that Mr. Patterson had the right to know, or conversely, he just don't commit the FDCPI violation and send requests for admissions with the summons and complaint. But
Well, I'm having the same problem, frankly, on the merits. The federal rules of civil procedure have requests for admissions and don't require the serving party to explain the rules to the recipient, do they?
no,
And presumably it wouldn't be enough just to give him a copy of the rule. You'd have to explain it to a pro se litigant, a potentially pro se litigant.
We actually
So,
have
it-
case law. Are you about to talk about?
No, go ahead.
Go ahead. So,
I'm
we have case law about summary judgments filed against pro se plaintiffs or pro se parties in this court, within the courts within the circuit, that require the moving party to provide a copy of Rule 56 and to explain it, in essence, as a matter of, in essence, just sound management of cases.
Good federal practice.
But without that being an actionable wrong, leading to damages and attorney's fees. If you fail to provide such a notice, you just lose your motion. But I'm struggling too with the idea that it's unconscionable to use a standard tool for discovery aimed directly at the merits of the claim in the state court to seek the defendant's position.
Well, the district court's analysis certainly did not focus only on the issue of, he needed to be provided. There were other issues that the court analyzed, including the fact that when this gets sent with the summons and complaint by the clerk, it appears that these requests for admissions are either coming from the court or endorsed by the court.
Well,
in
wasn't
some
the
way.
argument that it was confusing? The fact that there were instructions in the complaint summons saying if you don't respond within 30 days, you'll get a default judgment. That same warning, however, was not included, or no warning was included. There were the discovery tool, the request for admissions, that said if you don't respond within 30 days, they will be deemed admitted. And the lower court found because they were packaged together, they were served together by the sheriff's office, that with the complaint and the summons, that the discovery tool or the request for admissions were confusing, and that's what led to the procedural violation, is that it was misleading.
Yes, Your Honor. That's correct, and the court pointed out that exactly that the timing, even the court's words were an unsophisticated debtor, but even potentially a sophisticated debtor would be confused as to the timing on these issues and when the response was, and the response to the summons was commanded. You must do this. The summon, the answer to the request for admissions was requested. The word requested. So there were other issues here on top of the fact that they didn't advise the consumer that he needed to respond within 30 days.
What
Or
would
have
be
them-
wrong if, do you see any problems if we were to say, look, the mere service of these requests for admissions doesn't cause any harm. But if a defendant tried to use them in some way, then that might be a point at which a potential wrong had occurred.
I see that. I understand that. I don't think, though, that accounts for the fact that what happened in this case is that there's harm from the consumer, the defendant, later learning that they've admitted these things. They might have an attorney tell them.
What he learned, would you agree with me, is very incomplete. What he learned from you is that after 30 days, those are deemed admitted. You did not go on to tell him, however, apparently, that the court can grant relief, and as a practical matter, under the circumstances here where you filed a timely answer disputing the debt, such relief is very likely to be granted.
The court has the power to grant that relief, but as the district court noted, it might or might not. It also has the power to deny that relief.
The timing was when they were deemed admitted. So this intangible harm, what common law would you tie that to?
Essentially, it's deception. It's fraud. It's the common law analog to fraud and misrepresentation. Again, Mr. Patterson said, "Hey, if I'd have known, this."
Has any court, state or federal, ever deemed failure to notify a litigant about how state rules operate as a form of fraud? Judge Hamilton mentioned the requirement in federal court to notify litigants about Rule 56, but we don't view that, the absence of such a notice, as a fraud. It's just a reason to deny the motion. Any authority for treating the absence of such notice as fraud?
No, Your Honor just asked about the closest common law analog.
Yeah,
to
well,
it.
but a common law analog has to be a common law analog, right? The word fraud exists in common law, but you need to show that that word is applied to circumstances like this at common law. And you've just agreed that it's not.
I see my time is up. Thank you.
Thank you, Mr. Duff. Mr. Murray, anything further?
Your Honor, Trial Rule 36 expressly allows the service of requests for admission with the summons and the complaint. Presumably, that happens frequently, including in cases where the defendant who receives the complaint and summons is pro se at the time, whether it's a Fair Debt Collection Practices Act or some other type of litigation.
Most defendants are pro se when they first receive the complaint.
They are, Your Honor. And so this is certainly not out of the ordinary what happened in this case. I think it's also important to note that Mr. Patterson did nothing to defend this case for the entire duration of the collection action. And during the first 7 months of the case, he didn't even know about the deemed admitted request for admission. So it's not necessary to speculate what he might have done differently had the request for admit never been served on him, because the record shows that. He didn't know about them, and
Well,
he did not.
I mean, he
He
didn't
said-
read what was actually served on him? That doesn't seem a very good response.
I don't know how much.
You know about papers that have been served on you, and the statement, "I didn't read papers that have been served on me," hardly means you didn't know about them. You're deemed to know them.
Yes, Your Honor.
You can't say this contract doesn't bind me because I didn't read it, or I didn't know about papers that were served on me when they were properly served on me.
That's correct, Your Honor, and I should clarify to say he didn't have the advice of his counsel about the effect.
Right. He did not have a lawyer's advice about the legal consequences of that.
That's correct, Your Honor. And to the court's remark earlier about the consequences for not providing the notice to a pro se summary judgment defendant, as the court noted, that's remedied by denying the motion. Here, Trial Rule 36 provides the mechanism that the court noted. All he had to do was withdraw the admissions.
Well, he needed permission.
Yes, Your Honor, a move to withdraw the admissions.
So would this case be different, Mr. Murray, if Mr. Howe had filed a motion for summary judgment in using the failure to respond to requests for admissions 3 and 4?
I think so, Your Honor. If there had been any adverse judicial decision against Mr. Patterson, he'd have a much stronger argument.
Well, he'd have some other problems under the Rooker-Feldman doctrine, right? But I'm wondering about, suppose he just had filed the motion.
I do not know that, Your Honor. What occurred to me is that frankly, I think that if Mr. Patterson had even filed a motion to withdraw the admissions, I know this is a somewhat different issue, but if he'd incurred illegal fees to do that, I think he would be in a stronger position. But the record here is clear that he incurred no expenses and no legal fees in the collection action whatsoever. He admitted that during his deposition. So,
Why? I'm curious as to why Mr. Howe didn't offer to just withdraw the request for admissions himself after getting sued for having done it.
I believe that and again, this is not the
We're
record.
tens of thousands of dollars worth of fees into this, but okay.
Mr. Howe at no point referenced the request for admission to Mr. Patterson during the collection action. The record shows there was no discussion. Not only did he not use them, he never referenced them. It was as if they had never happened. That may be one reason why he didn't offer to withdraw them. Unless the court has any further questions, I see him at the end of my time.
Mm-hmm. Thank you very much. Case is taken under advisement. We'll hear argument now in the case of technical security integration against EPI Technologies. Mr. Sterling.
Good morning. May it please the court. This case, which seeks prevailing party fees in an underlying state court suit, should have been decided on an analysis of the prevention doctrine, as the defendant in this case, EPI, filed suit in the underlying case without any mediation ever taking place. Yet after EPI lost that case, they relied on the lack of the mediation, pre-litigation mediation occurring as a shield to avoid the prevailing party fees. The case fits squarely within the prevention doctrine, which
Counsel, I know the parties addressed problems of issue and claim preclusion in the district court and haven't done so here. But for my curiosity, is there any reason to believe that Illinois allows a prevailing litigant in suit number 1 to file a separate lawsuit, number 2, to seek attorney's fees from suit number 1?
Yes, Your Honor. So under Illinois jurisprudence, an exception to res judicata is where the suit or the judge in the underlying state court action expressly reserves the right to file a new suit, and that's exactly what happened in this case.
Is there some case you want to refer me to look that up?
Yes, so I know the for the exception to res judicata.
No, I'm asking a concrete question about whether Illinois has case law saying if you file and win if you win suit number 1, you can file a separate lawsuit seeking the attorney's fees from suit number 1.
I don't know if there are case laws specific to seeking attorney's fees, but there
Or
are
costs, or anything similar.
Are costs, but it does. There is a cause of action for prevailing party fees, and it's not precluded under claim preclusion or res judicata.
Well,
because
what's the case that you would cite? No, I'm not asking you, putting you on the spot, because I know the parties haven't briefed this question. So I don't expect you to know it by memory, but it was a puzzle to me when I was trying to work this case through.
Your Honor, I think we cited some of those cases in the underlying briefing, but one I would
briefs in
point
the
you
district
to
court.
is
All right.
Hudson versus
Well, we
City
can
of
go and look
Chicago.
at. If you did, we can go and look at that.
Thank you, Your Honor. On appeal, res judicata was not raised, and the district court found that the claim was not precluded because the judge in the underlying case specifically provided technical securities remedy is to file a new lawsuit because EPI had voluntarily dismissed the remainder of the lawsuit, and therefore the state court could not rule on the petition for fees.
Mr. Sterling, do you want us to order a trial?
So I would like you to order summary judgment for technical security.
I can't see how we could do that. What I see, you seem to want us to fill in a lot of blanks in section 16 of your contract as to schedules, terms about fees, terms about how to select a mediator, and so on. And what I see in the factual record here is each party pointing to how the other's representatives or lawyers were unreasonable, and that EPI went to court too soon.
Well, there are differing standards there, Your Honor. So the contract provides that the parties must mediate.
Actually, it does not. It's not a breach to go ahead and file suit. All that's forfeited is the potential for fees, right?
Your Honor, the contract says the parties shall submit the matter to mediation, and then it contemplates a 180-day cooling off period, and then the parties, only after that time, the parties are entitled to file suit. So it's not an optional thing where you can mediate if you want to seek fees or not mediate if you don't want to seek fees. The contract says the parties shall mediate. And
Okay, but again, the problem is whose fault is it here? They say it's your fault that your lawyers didn't get back to them in time, right?
that's correct. And
So
for
why,
them to show-
I'm trying to picture selecting a jury in this trial and explaining to them what this is going to be about. Which of these two groups of lawyers were more unreasonable and impatient, right?
Your Honor, that's right.
That's
But-
what it's going to be about.
But the degree of what occurred is different, right? So EPI here filed suit there's no doubt that the contract does not allow them to file suit unless there's a prior breach by technical security. Because the contract doesn't have any terms, as you said, about when to select a mediator, how that's done, the only way to fill that in is on a good faith and fair dealing or reasonableness basis. And that would be a fact-intensive finding to show that the waiting of 6 weeks when my client was seeking Illinois counsel was unreasonable under the law, and therefore technical security breached the contract. The finding under the prevention doctrine is not that. It only has to show if there's no prior breach of technical security under the prevention doctrine, EPI, if they wrongfully hindered the condition from occurring, and I think that's a pretty easy determination to make, that filing suit when the contract says you can't is wrongfully hindering the condition
From
from
their
occurring.
point of view, you guys were just balking, you were refusing to go forward with mediation. Now, I understand you've got factual disputes about that, and Ms. Yoon and her emails and her memory may come into play and all that. I guess I'd have a hard time seeing summary judgment for you.
Your Honor, they say we dawdled. Under the contract, it says the parties shall submit the case to mediation. There's no exception for
So under section
dawdling.
16, when would you have been required to file or respond?
So I think that goes back to a reasonableness evaluation, and in that you would have had to look. 6 weeks is not a overly long time for things to happen in the legal world, especially when there's a demand of a California small business and they've now got to find counsel and determine a mediator in Chicago. But that reasonableness determination has to take into account all those factors, but it also takes into account the conduct of the other party. It would have been easy for them to say, hey,
But so at
if you
what
don't...
point would EPI have been permitted to take further action? If we determined 6 weeks, that's sufficient, that's reasonable, or not, at what point would EPI have been permitted to take further action without any response from TSI?
So that's not in the contract, but what they could have done is said, hey, if you don't get back to us in the next 2 weeks, we're going to go ahead and file suit, or we're going to go ahead and say you're in breach under the agreement. They got none of that. Rather, they just went and filed suit without warning. And that goes into that reasonableness determination. And I believe without warning, and the fact that they just went ahead and filed in breach of the contract would entitle TSI to summary judgment. But going back to
I guess
that,
I'm struggling with the idea that it was a breach for them to file suit if they had reasonable grounds to think you all were dawdling and resisting mediation.
well, dawdling and resisting mediation is not a breach of the contract. So
Really? How long could you wait, to follow up on Judge Pryor's question? How long could you stall?
Well, I'm not sure. It would depend on the circumstances. But here,
Yeah.
there's no rejection of mediation. There's only that they're telling them they will get back to them and propose an alternate mediator after 6 weeks and a couple weeks after the last communication. They went ahead and filed. So
He was reaching out pretty much every 2 weeks.
he reached out twice, right? And that was while the
Every 2 weeks for 6 weeks. and then he
Attorney
filed
Handling
suit.
was on maternity leave, and there was another attorney, and they were trying to get counsel. But there's no analysis in the district court opinion that was a breach by technical security. That would have to be a factual determination, and that would foreclose the summary judgment that was awarded below. So it would be, I believe, easier to award summary judgment to TSI, but awarding it to EPI couldn't be done without the factual determination that we've been discussing.
Thank you, counsel. Mr. Glazer.
Good morning, please the court. Adam Glazer on behalf of EPI. None of what you just heard is in the contract. There's no contractual requirement that we issue a warning before filing suit. There's no contractual requirement that we wait not an overly long time, as I heard counsel say. The contract provides for mediation, yes, but it is not a requirement. It states in the contract mediation shall take place, but it also provides the contractual penalty for the failure to take place, which is the forfeiting your right to seek attorney's fees. And when we filed the complaint, we understood that penalty, and we did not seek attorney's fees in the original action we filed in the state court. What we did, Your Honors, we knew the parties had agreed to mediate under the sales representative agreement, the SRA. We demanded mediation July 29th of 2015. The response we heard was kind of a reflexive response. Even though we don't know your mediator, we reject your mediator and we will propose an alternative mediator. Fine. We heard nothing. We inquired again on August the 12th. The response that we heard at that time from the attorney, they hired an attorney in California. The attorney said that he'll check again. We heard nothing. We inquire again, this time on August the 20th, and the response that we get from the attorney, message received, we'll be in touch. Nothing. So by September 14th, we did file our complaint. We waited over 6 weeks from the time that we first demanded a mediation pursuant to the SRA. Counsel didn't answer the question about just how long we should have waited. If it took them 6 months to find a mediator that they liked or to find counsel, we should have waited 6 months.
Why isn't 6 weeks a question of reasonableness here?
The 6-week period, I think, is the evidence of its reasonableness is supported by the fact that the attorneys kept responding to us, kept saying, okay, we're going to respond, we're going to get to you, we're going to propose another mediator. They had plenty of time, which you heard up here a moment ago about some
It's
attorney.
not actually that much time.
But it's an ample period of time to agree to mediation. They didn't have to necessarily agree to our terms. They could have written us back if they needed more time and said, let's mediate on a date 3 months from the date you suggested. But we didn't hear anything like that. All we got was radio silence, other than vague promises to get back to us. 6 weeks, the district court judge was entitled to find that that was a reasonable time period in this
Acting
action.
as a matter of law or as a trier of fact?
Well, I think, Your Honor, reasonableness here as a matter of law. I think the idea that there are 6 weeks and that it wasn't like they never told us.
Who drafted Section 16?
Section 16 was the form contract, I believe, that was used by the plaintiff in the case,
By TSI.
TSI.
Okay. I mean, both of you seem to be asking us or the district court, in essence, to infer an awful lot of details here about a schedule, about how you pick a mediator, how quickly people need to respond to each other, right?
I don't know that we're asking you to assume a lot. I think objectively, everybody up here has practiced, and we know how you've been around a long time. If they needed more time than the 6 weeks, they could have written to us and said, look, we need another couple of weeks, and then we're going to go ahead and mediate. We didn't hear anything like that. There was no talk about a maternity leave. That comes up for the first time on appeal. We didn't hear that below. There was no talk about any other difficulties, in terms of finding a Chicago lawyer. After all, this is mediation, not court. Their California lawyer could have mediated the dispute. You don't have to be licensed in Chicago to mediate. They already had attorneys, in place. There's no reason in the world the mediation couldn't have taken place. We didn't require that the mediation take place within 6 weeks. We just required a communication acknowledging that they would mediate. And we gave them plenty of time to do that.
Did they say they would not?
They didn't tell us they wouldn't. They never came to us and said, we're ready to mediate. They didn't.
Why not give them a deadline?
Because the contract doesn't require it. It doesn't say we have to give
Wouldn't it be kind of reasonable before you go to court to at least say, we think you're jerking us around here? It's time's up?
That was exactly the thinking. But our view was we gave them 3 chances. We kept writing to them. We weren't required under the contract to write to them more than once.
You want to make these arguments to a jury?
I think the arguments played well in front of the district court judge.
They obviously did.
I guess the question that's been raised now is that 3 weeks after you filed suit, TSI did reach out and said, we are open to mediating. Was this considered below when interpreting section 16?
Judge, understand that they could have filed a motion with the Cook County Circuit Court saying, let's stay the case in favor of mediation, let's dismiss it in favor of mediation. They could have taken any action at all, but during the whole pendency of the Cook County litigation, they never took any action to say that we're ready to proceed with the mediation. They didn't, I don't believe they came to us, I don't believe they came to the court to say, let's go ahead and mediate. The only time this came up, the only time perhaps they were even aware of it, was after the case had been adjudicated on summary judgment, partial summary judgment, and then they sought fees, and that's when they learned for the first time, apparently, it's the first time it's mentioned in the pleadings, that by failing to mediate, they had forfeited the right to recover the fees.
No, there's a declaration from Ms. Yoon where she declares that she did reach out and attempt to mediate in October, about a month after the case was filed.
Yeah, that's just not our understanding, and Ms. Yoon doesn't even remember it that way. She says, of course, that she doesn't have a recollection, but that she made some sort of note to that effect. But no one on our side ever recalls them coming back to us and offering to mediate at any time. Not before, not after the case was filed. I understand that's in a declaration somewhere that wasn't considered, but the fact is, if they had done that, why didn't they come to us again? If they really think that that phone call was sufficient, they had attorneys in place in Chicago by now. Why didn't the Chicago attorney, why didn't Mr. Sterling pick up the phone and say, Adam, we're ready to mediate?
Do we know why it wasn't considered, that declaration, in raising that fact question?
Well, it's referenced in the footnote in the district court opinion. We argued, of course, that it should be stricken. He denied the motion as moot, but he didn't explain why he didn't actually consider the declaration. Clearly, it was not on firsthand knowledge.
Why isn't it just recorded recollection?
Well, we don't have all of that information, of course. What they did is they produced a heavily redacted document to us, so we don't exactly know whether it has the makings of a recorded recollection. All we see is what they choose to give us. We don't know exactly the nature of that alleged recorded recollection. So look, we attempted, we tried. Contract didn't require us to demand it more than once. We came back to them 3 times, and they did, in fact, jerk us around, Your Honor. We tried to go back to them. They stalled us. There was no indication as to when, if ever, they were going to respond and proceed with the mediation. We're not required to sit on our hands forever. We gave them over 6 weeks, nothing. We went ahead and exercised our right to file.
But never gave them a deadline.
We did not give them a deadline, nor were we required to give them a deadline. That's after the fact thinking.
Oh, there's no time limit for their response, is there, in the contract?
There's no time limit. It doesn't say anything about a time limit for either side.
Exactly.
But if they're going to come into court and argue to this court that 6 weeks is unreasonable, I'd like to see a citation. I'd like to see some authority where some other court has said waiting 6 weeks to file a lawsuit, not sitting on your rights, is not reasonable. And I'll point out one other factor. You know, there's no choice of venue provision in the contract. So by giving them all this additional time, we were running a risk that they would turn around and file a deck action in California before we got to court in Cook County. So we had to be mindful of protecting our rights. Our guy was deprived of commissions. He was not getting paid. He was anxious to have his day in court in the circuit court of Cook County, not out in California. So we thought 6 weeks was more than enough time. Thank you, Your Honors.
Thank you very much to both counsel. The case is taken under advisement. Tutwiler against Kijakazi is our next case for argument. Ms. Young.
May it please the court, my name is Ann Young, and I represent Heather Tutwiler.
Ms. Young, could you raise your voice, please? This is a big room, and that microphone records but does not augment very much.
Sure. My name is Ann Young. I represent Heather Tutwiler, the plaintiff appellant in this case. Ms. Tutwiler suffers from a number of physical ailments. Starting in 2014, she had endometrial cancer. After that, she had an incisional hernia repaired that required her partial small bowel resection, followed by her gallbladder removal. Since these procedures, she has had continuous vomiting, nausea, and diarrhea that affect her daily life, and it has progressively gotten worse throughout the process of all of these different conditions. She testified that after her gallbladder removal, she has not had a normal bowel movement since. The vocational expert testified at the administrative hearing that the tolerance for being off task in competitive employment was 10%, and an employee could miss just one day of work a month to be able to still perform competitive employment. He also said if an individual is away from the workstation for any reason, it would be problematic and that they could be reprimanded and or dismissed. He also said that, the vocational expert also said that if you are actively puking while on the job, you would be dismissed by your employer. The ALJ in this case did not consider the time off task or the absences that would be caused by Ms. Tutwiler's conditions. When considering the evidence, the ALJ ignored entire lines of contrary evidence and failed to build a logical bridge from the evidence to the conclusion.
Looking to the medical record, Ms. Young, how many times a week does the record show that she was having these issues? You use the word continuous.
She testified that she vomits 2 to 3 times a day. Throughout the record, there's various, at the beginning from 2017 to 2018, it's a couple times a week, and then by the end of the record, her physician, Dr. Wu, did state that she has, I believe it was regular vomiting and regular diarrhea that affected her daily life.
Was she still being treated
Yes.
for the
Yes.
vomiting and the nausea and the
Yes,
diarrhea?
she was still being treated, and her physician said that the medication that she was on for the nausea, she was likely to develop a tolerance to, so that it would be less effective as her conditions progressed.
And does the record show, the medical record, that she went months without throwing up, in essence, that she was improving?
I don't believe it shows that, no, not to my recollection. A lot of what the ALJ was citing too was from 2017 and 2018, which is prior to the period. The period started in August of 2018, and that is when she had her hernia repair done. In 2018 is when she had her hernia repair, and then she had her gallbladder removed in 2019, and she said that her symptoms got worse from there. The main part that I want to focus on is in August of 2020, Dr. Wu did an EGD, which is an esophagastroduodenoscopy, and it found that there was severe bowel dysmotility, that she had severe bowel dysmotility. And this is something that the ALJ never discussed, and something that the agency consultants never saw. So they never saw it when they gave their opinion to the ALJ, and the ALJ never considered it in the ALJ's opinion. The ALJ did discuss a 2020 manometry procedure, which said that it was suggestive of intrinsic neuropathy, but that clinical correlation was needed. And the ALJ focused on the fact that clinical correlation was needed for that procedure to confirm the intrinsic neuropathy, but then the ALJ never discussed the later one, the August EGD, which did find severe bowel dysmotility.
Would it have been possible for her to hold down any of these jobs proposed by the vocational expert based on Dr. Wu's diagnosis?
So no, she works a part-time, well, she did up until 2 weeks prior to the hearing. She worked a part-time position, and she was let go from that part-time position because of her active vomiting on the job. She was sent home multiple times because of the active vomiting, and then the employer let her go, and because of this, and they wrote a letter that said, I was trying to find the exact verbiage, but it says, please bear in mind that we believe it is likely that your failure to appear for work is due to your serious medical condition. To that end, we are making you eligible for rehire should you wish to return. So they let her go because she was vomiting regularly on the job and was unable to perform her duties while she was having severe diarrhea and vomiting. And she also testified to that her employer was aware of her situation and that she was regularly sent home because of it. She also testified that she has consistent accidents due to the diarrhea that she suffers from. So looking at the evidence, the ALJ failed to consider this EGD by Dr. Wu and then disregarded the earlier February 2020 manometry because the notes in that test stated that clinical correlation was needed for it. The ALJ also failed to consider her significant weight loss throughout this whole process. She lost over 100 pounds during all of this, and she's still, her current doctor says that she's unable to gain weight. Dr. Wu said that. And
Were these subjective, evaluating her subjective symptoms, was any of this raised below
yes, her symptoms, and you mean at the district court level?
the argument?
Yes, it was raised that the ALJ failed to consider the time off task and the absences that would be required due to all of her conditions. Yes. So she did lose over 100 pounds from 2017 and 2018, and she was also diagnosed with acute kidney injury, which they said was likely due to dehydration. The ALJ, actually, can I save the rest of my time for rebuttal? Is that, unless you have further questions?
It's up to you.
Okay, thank you.
Thank you, counsel. Ms. Siegel.
Good morning, Your Honors. My name is Catherine Siegel. I represent the Commissioner of Social Security in this case. The main issue before this court is that the claimant argues she would need excessive work breaks and absences due to her gastrointestinal symptoms. I would like to clarify that the onset date was amended at the hearing to January of 2018. So her criticism of the administrative law judge referring to evidence from 2018 is not well taken. The claimant has failed to establish that she had work limits beyond those that the ALJ assessed. First of all, the record shows that her symptoms were intermittent, not all the time as she testified, and that is supported by the medical records, in particular from her gastroenterologist, both Dr. Akbar and Dr. Wu. Dr. Wu, in August of 2020, which is a record that the claimant is citing as a support for having the symptoms all the time, actually cites intermittent symptoms on both page 1792 and 1793, which is where that report occurs in the record. Dr. Wu's report does not establish any restrictions based on her symptoms. He did not give any kind of assessment, did not make any statements in that report that suggested she had any limitations, and in fact uses the word intermittent to describe her diarrhea and said that it was for many years, but that she recently had improvement over the past couple of months. That's at 1792. With regard to the bowel dysmotility, that condition was being treated with Cipro, which is an antibiotic. And although the claimant said that it was not effective, the Dr. Wu, her gastroenterologist, said that she should continue using that medication and that she should use it for 10 days every 3 months. So it was a continuing type of preventative medication that she was using it to treat that condition.
He prescribed 2 additional medications on 1793 as well that also addressed vomiting. So he was still treating the
Yes.
intermittent vomiting. Okay.
Yes, and from what the doctor said, that those were effective treatments, and that he characterized her condition as intermittent, so not constant, as she testified. Importantly, in that same report from August 2020, Dr. Woe stated that the claimant is doing okay, and that but she had intermittent abdominal distension and emesis persists, and he recommended continuing the same treatment.
With
also-
the intermittent that Dr. Wu found, did the ALJ make a determination?
The ALJ did not cite that specific record in his decision, but he was not required to do so because with regard to articulation and
Not citing the evidence, did he make a determination of how often, the intensity or the extensiveness of the diarrhea, nausea, vomiting? We have the state agency, Brill, who made the determination that she was vomiting at least once every 3 days. We have Dr. Wu, who's determined that it's intermittent. Did the ALJ make a determination regarding the intensity or how often these were occurring, because there were severe impairments found of vomiting? So I would just interested to know, did the ALJ make a determination?
the ALJ looked at what the doctor said about her conditions, and the state agency reviewing physicians had reviewed records that also addressed her vomiting from Dr. Akbar, who was her other gastroenterologist. And again, Dr. Akbar did not assess any limits that were related to this. So when the ALJ assessed her condition, he relied on the statements from those state agency reviewing physicians that said that she was capable of working. The doctors at the state agency said that she could do a light work capacity, and that there were other occasional postural limitations and pulmonary restrictions and no severe mental impairments. But the ALJ found those were somewhat persuasive, and then looked at her symptoms, about the statements that she made both at the hearing, which were very extreme, and alleged that she could not work at all because she had these symptoms all the time. And then he compared that with what she told her doctors. And throughout the decision, he cites specific medical records where he talks about what the claimant said to her doctors. And those are the kinds of articulation that we have about her symptoms. And by comparing the actual statements and then the contradictory statements to her doctors that she doesn't have these symptoms all the time, he was able to weigh whether he should credit a restriction. And based on the fact that there were no doctors who gave any restrictions for this condition, and that her symptoms occurred intermittently, he limited the claimant to a sedentary work capacity, in part based on her abdominal pain statements at the hearing, and also based on some of the statements she made about nausea being triggered by walking around. So instead of having a light work capacity, which requires walking, he limited her to sedentary work, which does require walking. So,
I guess my concern is when the vocational expert says she'll be fired for vomiting at work once in a 90-day period, and so, or twice in any month. If she worked 40 hours a week or part-time, and so if that's the representation made by the vocational expert, did the ALJ have to, in essence, somehow deal with that or make an assessment as to why a functional limitation would not be needed?
So that when a vocational expert makes those kinds of statements, they're basing it on a functional capacity that is established by the evidence. And here, the functional capacity that's established by the evidence is the one that the ALJ ultimately found.
The sedentary?
Because it was based on actual physicians who reviewed the record, including things about her symptoms, and they concluded that there wasn't any basis to limit her more than what the ALJ found. So even though we have testimony by a vocational expert that hypothetically this would cause an inability to work, because that hasn't actually been established in the record with an objective basis, not just the claimant's testimony, the ALJ was not required to credit that testimony. There are a number of issues that the claimant raised in her brief that are forfeited, and we stand by that contention that the only issue before the court has to do with her excessive gastrointestinal symptoms causing work limits. So if there are no further questions, I ask that the court find that the commissioner's decision is supported by substantial evidence, and ask that you affirm the decision.
Thank you, counsel. Anything further, Ms. Young?
Thank you. I just wanted to address a couple of things. It was mentioned that the doctors did not make an assessment of her functional limitations, her treating physicians. However, they did note multiple times that she's having severe nausea and vomiting. It's happening multiple times a week, occasionally more than one day. They noted complaints of severely impaired quality of life, and that was in August of 2020. In May of 2020, they noted still having diarrhea. Unable to gain weight, will likely develop a tolerance to her medication for nausea. So they did not assess limits, but they certainly elaborated on the issues that she was facing. As far as the state agencies and the functional capacity, it was mentioned that the physicians concluded that there was no basis to limit her more than the ALJ had found. However, the physicians did not, they just answered questions about her functional limitations as far as how much weight she can lift and what environmental hazards she should not be susceptible, or she should not be exposed to. But they did not answer questions as far as, will this condition cause her to be off task more than a certain amount of time? They were answering solely functional limitation questions. So I think that's very important to pay attention to, because the ALJ came up with that on his own, and the ALJ found these consultants only partially persuasive. So there was nothing else that the ALJ was relying on as far as a medical opinion goes for the residual functional capacity, or for the ultimate conclusion that Ms. Tutwiler was not disabled. And I believe it was mentioned that there were other issues in our brief that were brought up that was not that were not preserved, but I cited some cases in the reply brief that they were indeed preserved, because we brought up the overarching issue of the residual functional capacity, which is sufficient.
You think that's enough to just arguing we're challenging the RFC so we can bring up entirely new issues that were not addressed in the district court, including the drugs, the alcohol, the tobacco, and the concentration and persistence issues?
So those are not new issues. Those are issues of how the ALJ evaluated the symptoms, and how the symptoms were evaluated is certainly related to whether or not those symptoms would cause off task. But I'll also go back to the main question, that I do think it's sufficient. And Arnett v. Astru, they said that it was. So that's all I will. Thank you very much.
Thank you, counsel. The case is taken under advisement. Willow Way against the Village of Lyons is the next case for argument. Mr. Bolton.
May it please the court, I will attempt to reserve 3 minutes for rebuttal. Your Honors, I'll take it a bit out of order so as to not run out of time. Going to the eminent domain count 3, Your Honor, it appears to us that the village does not contest that Judge Chang improperly did not exercise his diversity jurisdiction. They simply make a jurisdictional attack based on damages, Your Honor, but that was never raised below.
Well, the problem is, if you are effectively saying that jurisdiction was conceded in the district court, and you can never concede jurisdiction. It is open to challenge at every stage of the case, even before the Supreme Court, even if we ignore it. What the village is saying is that the state law claim depends on the diversity jurisdiction, and that depends on more than 75,000 being the amount in controversy.
Indeed, Your Honor.
So what in the record shows that the amount in controversy exceeds 75,000?
There is only the $15,000, Your Honor. I concede that there's only the $15,000 in the record. However,
That's the purchase price of the parcel.
no, that's not the purchase price of the parcel. That was an escrow required by the city, which was
All right,
village,
an
which was
escrow.
never given back.
All right.
That
What
one-
does the record show about the purchase price?
The record does not show the purchase price.
What does the record show about the current value compared to the purchase price?
It does not show the current value.
Are there any allegations about the purchase price or the current value?
No, Your Honor, but there is our amended jurisdictional statement 27-1 where we listed out for this court the damages that are claimed by Willow Way and challenged by the court as to the jurisdictional amount. We did provide the claimed damages in our jurisdictional statement. Your Honor, it is before the court as far as this court, and it is detailed.
Do you want to file an amended pleading under 28 U.S.C. 1653? Were you here, I trust, when we discussed this with counsel in an earlier case?
Yes, Your Honor, if Your Honor wants us to detail out what our
Well,
claim is.
Since your briefs don't even try to explain how the amount in controversy exceeds 75,000, I think if you have any chance on the diversity branch, you're going to need to file an amended complaint and ask us to permit you to do it under 1653.
I will, Your Honor.
And in particular, I guess I have trouble seeing, you've identified various out-of-pocket expenses, but I would think that your damages would be, in essence, the difference in value in the property the day before the demolition occurred and after it occurred.
Part of it, Your Honor. But as in our answers, as we said in our jurisdictional statement, our out-of-pockets go with the $15,000 that was deposited with the city. We spent a considerable amount of money attempting to renovate this property, which was essentially eliminated.
Well, but the question is, what was the property worth, in essence, the moment before the wrecking ball swung, right?
Yes, Your Honor, that's certainly
Whether your money up to that point had been spent wisely or not.
true, Your Honor, and that is certainly a central contention, and it is certainly a central issue. I don't disagree with you
Well,
about that.
if you're going to take advantage of your opportunity under 1653, please do listen to Judge Hamilton and address that question.
I did listen, Your Honor.
What was the effect of the demolition on the value of the property before and after?
I understand, Your Honor. I acknowledge. Your Honor, our essential, as to the takings issue, our essential position is that the judge below agreed with the appellees that all they had to do was declare it a nuisance, provide notice, and everything is over. What we have stated in our brief and provided a substantial record is that what we are in a different question, which is what happens when the village has affirmatively prevented the completion of the renovation with a building permit, Your Honor. And part of our argument is that, as recognized by Judge Koukouras in the appeal case, the building permit under Illinois law does present a property interest that is defensible and can be a taking. So if the
Supreme Court of the United States has held that permits are not property interests.
Yes, Your Honor, I understand that. I'm simply
Well,
going under
yet
Illinois.
decisions of the Supreme Court supersede decisions of federal district judges.
Thank you,
It's
Your
a
Honor.
perfectly straightforward.
Thank you, Your Honor. We are going to the point of what happens when yes, thank you, Your Honor. We are going to the point of what happens when the village has affirmatively blocked these groups from completing their project.
So didn't your contractor testify the problem wasn't a stop work order, but that he wasn't getting paid?
Well, he eventually left because he wasn't paid, Your Honor, but he also stated that he couldn't cooperate. The city was giving him no cooperation. One of the prime ones, Your Honor, being the last report of October 2017, when Mr. Pierce took 4 steps into the building and then admitted that he made all of his determinations over photographs when he had no idea how old those photographs were, and then turned around and did.
Mr. Bolton, let me
Yes, sir.
cut to the chase here since time is limited.
It is, Your Honor.
We have, the concept of a nuisance is pretty well understood in the law. And Illinois, as near as I can tell, provides ample procedures for resolving such disputes before a wrecking ball swings, right? If we accept your theories here, please tell me how we avoid turning, in essence, every nuisance condemnation into a federal case.
Well, Your Honor, I would go to the facts, and that it is a standard that you would adopt. I believe that the facts here don't show mere negligence. The facts here demonstrate an affirmative desire of this city that this project not be completed. For example,
Well, okay, what that suggests to me, though, is that anytime a property owner, for whatever reason, leaves a property in terrible shape, and a city moves to condemn it, and the owner does not take advantage of the procedures provided by state law, that you're in federal court contesting negligence or willfulness or personal vendettas or political vendettas or whatever, but it's all going to come into a federal court.
Well, Your Honor, the issue here, though, is the egregiousness of the conduct, and I see I'm at 3 minutes, Your Honor, but I'd like to answer your question. Your Honor, we have a case here, and as Penn Central said, these are
What you're saying is, this is a really bad case, so we're entitled to be in federal court.
Penn Central stated, and the Supreme Court in Penn Central stated, there are no bright lines. It is a fact-based determination. They don't. The
Penn Central case was not about the demolition of a hazardous building.
True, Your Honor.
Nor did it concern the adequacy of procedures in Illinois. I wish you would deal with the question Judge Hamilton asked.
Your Honor, I will, Your Honor. I am going to the issue of the fact that there was willful conduct here. For example, number one, the attorney was lied to on the day of the demolition, saying, we will work with you, don't worry about it, while the demolition was going on. Village officials and City Hall lied to our attorney. Number two, they put together a report which they relied on and declared a nuisance, and they admitted they never gave that report to Willoway. They never told Willoway what had to be fixed.
In December, did you receive ample notice? Did Willoway receive notice in December that this was going to be, the city was taking this as nuisance, and this was going to be?
We admit that it was sent to their premises in California, Your Honor. They did receive it, which is when they began to make an attempt to engage the city. However, as John Pierce, the building inspector, testified,
But this doesn't happen until February.
Well, they made attempts all through trying to get through to the city. What happened, Your Honor, is that the city, I apologize, Your Honor, the city did not engage with them. John Pierce testified that once he made his decision in the fall or the summer, everything would roll and there would be no change. There would be no remediation. There would be no discussion. And they made good on that by not.
Was there a stay filed for the demolition process?
I'm sorry, Your Honor?
Was there automatic stay? Was there anything filed to stay?
No, Your Honor. We admit that there was not. But our point, Your Honor, is that when the village takes the affirmative actions that they did, then we are in a different realm, Your Honor, that they cannot hide behind the prophylactic protections of notice and a declaration that it's a nuisance when the village has participated in maintaining that nuisance by preventing them from completing the project. I thank Your Honor. I would just want to reserve the rest of rebuttal. Your Honor, I will waive rebuttal only because I'm at 45 seconds and we've gone on.
Well, you may choose what to do once you hear what Mr. Murphy has to say.
Thank you, Your Honor. I apologize about the paper.
Mr. Murphy.
May it please the court, I'd like to follow up on two of the points Judge Hamilton raised. The first dealing with diversity. The issue of how much money the owner, plaintiff may have spent on the property, at best becomes part of the basis in terms of what Your Honor said was the value of the property the day before the demolition. That goes into that calculation where there is zero evidence on that point. And then to get to the takings issue, in terms of this statute, Judge Pryor, record's undisputed that the statute requires multiple forms of notice. Placard notice, public record notice, actual notice, law bulletin notice. They received every single form of notice which the statute requires. The record is undisputed that the CEO of the company received actual notice of the pending demolition, including the citation of the statute. Every single argument which plaintiff is making in this case, that this was an improvident or bad demolition of property, could have been raised as a defense to the demolition action. How? By taking what this court referred to in 1997 as a rudimentary precaution. And that rudimentary precaution is, once they got that notice, not to let that 30 days expire, and file a simple complaint in the Circuit Court of Cook County, in this case in Bridgeview. And that effects an automatic stay. Once that notice is filed in court, the village's efforts to demolish that property must cease. It then becomes the village's burden of proof to show that that property should have been demolished. That's where cost benefit comes in. That's where all of these factors that would come into the balance in a regular demolition case be litigated. Had they simply followed the statute and protected their rights, we wouldn't be here today. Why? Because they could have defended the case. They chose not to. The argument that on February 27, building inspectors said, well, we won't demolish, but we demolished it, that's a defense. That could have been raised, it could have been prevented by timely notice and suit in state court. It could have been used as a defense in a subsequent lien foreclosure action. The statute is property owner friendly. The statute helps property owners who help themselves. And it doesn't take much to help yourself. And the fundamental question that plaintiff ignores has nothing to do with Penn Central. It's the principle that in takings law, nuisance is part of the common law of property. Nobody has the right to have a nuisance property. And that the Supreme Court just reiterated that in the Cedar case. So the statute in this case makes explicit what the common law has recognized forever.
Right, but the problem is, I mean, there are an awful lot of consequences that flow from the designation of a nuisance, right? But the question is whether the designation of being a nuisance is subject to some kinds of either substantive or procedural protections under the Constitution, right?
I would say yes, the due process clause, and this statute provides all the due process necessary.
It's got procedure. It's hard to imagine more procedures.
Up the yin-yang.
Or more, yeah, out the yin-yang or whatever. But in terms of substantive standards, I would think that if let's suppose I understand you don't think that's what happened here, but that if a local government decided, in essence, we're gonna dream up some new standards for what amounts to a nuisance, that there might be some constitutional limits somewhere out there.
There could be. Now, the mere demolition of a house is not. Why? Because on the mere demolition of the house, the owner has not lost title. That is one stick in the bundle being taken away. On the other hand,
It's a big stick, but
in this case, it wasn't many
It's got a lot of
sticks.
sticks in it, actually.
If you look at that house, it wasn't many sticks in there, including no front porch. On the other hand, if the,
But you surely would agree, forget about substantive due process for the moment. If the village demolishes something without a rational basis for doing so, that's a classic equal protection claim, right? Now, the ability to litigate in state court might be all the protection that's required for that kind of claim. But I trust you're not denying that there are some limits on whether the village can just wave its hand and say, we just want to knock this one down. We haven't knocked one down in a month. We like knocking things down.
I'm well aware of Mrs. Olick. So if this were a class of one equal protection case, fueled either by an invidious discrimination or a completely irrational aspect, that might be an equal protection claim. So there are constitutional limits. But on the takings angle, I make the point in our brief that let's assume that we demolish the building and then say nobody can build anything here because we think it'll cause drainage problems. That's a potential taking.
Actually, we would call that a zoning decision.
And
And then we'd say this village can have what zoning rules it likes.
and that the federal court is not a board of zoning appeals, as Your Honor has said on multiple occasions.
We have indeed.
You have indeed.
So I think on the, one of the problems that plaintiff created in this case procedurally is, number one, they didn't follow statute, and number two, when Judge Chang issued the summary judgment rule and dismissed without prejudice on supplemental jurisdiction, plaintiff should have filed a motion to reconsider, saying, wait a minute, we have a diversity claim here. They didn't do any of that. So, Your Honor, I think, unless there are any further questions, I think you understand our point in this case, and we ask that we be affirmed.
Thank you. Well, you've got 46 seconds, counsel. Mr. Bolton, have you reconsidered?
Brief by necessity, Your Honor. Your Honor, I would simply state that in claiming that we could have filed the lawsuit and that would have stopped the entire incidents of February, it's quite an argument to say that you should have filed a lawsuit so we wouldn't have to lie to you, which is essentially what you just heard. My point, Your Honor, is that I think Your Honor's questions go to the heart of the matter, which is when a municipality has acted arbitrarily and irresponsibly in an attempt to obtain property for whatever reason. We're not saying that we ever recovered a reason. That when that occurs by affirmative conduct that prevents a homeowner from completing the project by actions of the municipality and omissions of the municipality that were intentional, they have no right to claim the prophylactic protections of the state statute, because now we are going into a different type of entity where we're in that sort of gray. I notice my time is up, Your Honor.
Thank you, counsel. Now, we invite you, Mr. Bolton, to file within 14 days any supplemental allegations you might have under 28 U.S.C. 1653 that would show what injury was caused by the demolition, not other things that might have happened,
Yes, Your
but the damages caused by the demolition. Okay?
And I thank you for reciting the statute again, Your Honor, because you saved me a trip.
Mr. Murphy, you're free to respond.
Thank you, Your Honor.
The case will be taken under advisement when the supplemental filings have been received. And our final case of the day is Lynch against the United States.
Good morning.
Mr. Jesser.
Thank you, Your Honor. Good morning, Your Honors. May it please the court, Ms. Lynch is here to honor the court. Your Honors, before I begin my short argument, may I ask if the court has any initial or threshold questions of me?
Oh, I have a big one. Who is the defendant?
United States, Your Honor?
The United States. The United States has filed a brief on the assumption that the defendant is Scott Noland and doesn't mention litigation against the United States, whereas your brief mentions the United States and not Scott Noland. So the plaintiff can choose who you wish to litigate against, but the briefs are completely talking past one another. So you say the United States is the defendant.
Yes, Your Honor.
Okay. So the only claim against the United States is one that would be supported by the Federal Tort Claims Act. How does the Federal Tort Claims Act support this suit, given the exemption in 28 U.S.C. 2680H?
I'm sorry, Your Honor, I'm not familiar with that.
Well, if you're going to sue the United States, you need to know the Federal Tort Claims Act. It says claims sounding in false arrest or malicious prosecution cannot be brought against the United States. That's what 2680H says. It seems as straightforward an exemption as one could imagine.
I have no rebuttal to that, Your Honor. I would suppose that would be dispositive, Your Honor.
Well, if the United States is the defendant, 2680H and anything else in the Tort Claims Act is. By the way, the Tort Claims Act does not allow suit on constitutional torts. It has to be common law torts, and the United States is liable to the same extent as a private party would be. That's the core of the Federal Tort Claims Act. So if the claim is that the United States is liable because it's a governmental actor, that's wholly outside the scope of the Tort Claims Act. Just completely outside it.
And therefore, the action would not lie, Your Honor. Ergo, the action would not lie.
Well, the Tort Claims Act authorizes suit for common law torts, as it says, where the United States would be liable under state law if it were a private person. I mean, this is just what it says.
Mr. Jester, there is a proviso in 2680H regarding, among other things, claims for abusive process or malicious prosecution. Again, limited, though, to the role of a private individual.
Again, I'm not conversant with that proviso, Your Honor.
Let's suppose you're wrong about whether you've sued the United States or that you've also got a claim against Agent Noland. I guess the question that I have most fundamentally is, we understand that your client was acquitted. We understand that the licensing board decision was eventually set aside. It's hard to understand how any of that affects probable cause at the time of the charges being brought against her.
Yes, Your Honor. It is our contention that the district court should have taken that into account.
I'm not sure I can count how many cases in which this court has explained that when you're seeking civil relief on a supposed lack of probable cause, you look at what is known to the law enforcement officers and agents at the time that they acted, not anything later.
And I'm aware of that line of cases. I had no case law to support our argument other than to urge the court that the district court committed plain error in not taking into account 27 jury verdicts of not guilty.
That line of cases that I just described to you would have told the district court that is utterly irrelevant in trying to decide the question of probable cause back when the investigation was going on and the charges were being brought.
I can't dispute that, Your Honor. I had thought that it was relevant. Well, I understand what you're saying, Your Honor, certainly.
Okay?
Yes. I see that I have 4 minutes. If I could reserve that for rebuttal, possible rebuttal, Your Honor.
Certainly, counsel.
Thank you, Judge.
Mr. Moore.
Good morning, Your Honors, and may it please the court. David Holler on behalf of the United States. Your Honors, my opponent's notice of appeal did include both the United States and Mr. Noland, and we proceeded on that basis.
But his brief doesn't even mention the word Noland.
It doesn't mention Nolan, it doesn't mention the FTCA.
People can choose what arguments to pursue and what arguments to abandon. And it does seem from the appellate brief that any claim against Noland has been abandoned.
Well,
But yet your brief doesn't even try to explain why the United States, which the brief does discuss at length, is not liable.
well, Your Honor, the district court ruled in our favor on the probable cause ground, which knocks out any FTCA claim and any Bivens claim, and seemed the easiest way to resolve the case. I mean, under Indiana law, if a private witness walks in and makes a bunch of false and scurrilous allegations, that would be a malicious prosecution claim. So if that's the claim that's being raised, then I guess we believe that could perhaps be raised under the FTCA. If the court wants to knock it out at that stage, that's fine.
Not under 2680H, which says malicious prosecution claims cannot be pursued against the United States.
Well,
As I said to Mr. Jesser, I'm just shocked. The briefs appear to be addressing completely different cases. Mr. Jesser addresses a claim against the United States, but not Noland. Your brief addresses a claim against Noland, but not the United States. We generally expect the appellate lawyers to agree on what the case before us is.
I don't know entirely how to respond to that, Your Honor, other than to say that this case was litigated in the district court under these Fourth Amendment theories. That's how it was dealt with at the summary judgment stage. And we made the best we could out of the brief that was given to us. Regardless, all of these claims, whether they're preserved, present here or not, are clearly knocked out for the reasons Judge Hamilton already explained, because there was abundant probable cause up the yin-yang or whatever you want to call it here. The doctor said, I never gave this woman authority to prescribe in my name, and that's what she was doing. And when we went to Ms. Lynch, she wouldn't talk to us. So we inferred that it was okay that what she was not doing was proper, and we charged the case. This court has made clear that subsequent acquittals, subsequent proceedings for the nursing board, whatever, are totally irrelevant to all of that. So the FTCA claims are barred. Any Fourth Amendment claims that remain against Agent Noland are barred. And there's no basis for any claims here. Summary judgment was properly granted.
You had a number of options available to you in opposing these claims, including the imminent demise of Bivens claims, more generally.
Well, Your Honor, we thought of that as well. I mean, I think there's Greenpoint.
I expect you did.
And again, we just tried to deal with this claim on the simplest manner we could that would knock out any Fourth Amendment claims and any Bivens claims. And I think we felt it was so clear that we prevailed on that grounds that we didn't perhaps preserve other arguments that, in light of the way this case has now been litigated on appeal, might have been even simpler. But that's the way we proceeded. And however the court wants to resolve the case, the court's free to resolve the case. But I don't think there's any way to resolve this case in the plaintiff's favor.
Can I just very briefly ask you to explain to me what you understand the proviso in 2680H to mean? And how much it looks to me like it gives back what the opening sentence took away.
I'm not as intimately familiar, perhaps for the purposes of this argument, with the FTCA proceedings as I would like. I mean, there are some exceptions for agents and things like that, where some of these claims can be brought in sort of the more traditional Bivens contexts. And traditionally, some of these Malley versus Briggs claims are brought under the Fourth Amendment. I mean, they really are rarely brought under the FTCA because they can pretty much almost always be brought for the same reasons under the Fourth Amendment.
But not against the United States.
Well, right, but under the FTCA, the United States is going to be substituted as the party. You can only litigate an FTCA claim against the United States.
But you can, since the briefs talk past one another, the United States can be liable under the Tort Claims Act only when a private party would be liable for equivalent behavior, right? Private parties are not liable for violating the Fourth Amendment.
Well,
It doesn't apply to private parties.
Right. I mean, under the complaint, the claims under the FTCA are Indiana law claims. They're claims that under Indiana law, there was an Indiana false arrest and an Indiana malicious prosecution. You can sue a private party in Indiana for malicious prosecution.
Right, but not on a Fourth Amendment theory. It has to be a straight state tort theory.
Right. I understand what you're saying, Your Honor, that tort elements would essentially collapse into the same sorts of things here. Did the witness maliciously make statements, believing them to be false, one of which happened here? So there would be no claim for that reason either.
Under the FTC, isn't it a little more tricky though, because Nolan is not an agent?
Nolan is a diversion agent, Your Honor.
He's a diversion investigator.
He's a diversion investigator, yes. I mean, there's been litigation about exactly what the status of those individuals is as to whether we could bar the claim on that ground or not. So,
And what's your finding? Because he is not an agent.
because he's not an agent, I mean, our belief is because he's not an agent that he can't be sued under those specific grounds either. Again, like I said, there are multiple grounds on which we could have moved for summary judgment in this case, but because there was no lack of probable cause, there could be no claims against him. And there also can be no claims against the United States because there was no tortious conduct here. There's no evidence of malice. There's no evidence of a lack of probable cause. There's no evidence of anything that would allow any of these claims to keep going. I mean, this case only survived the motion to dismiss when an amended complaint was entered that the original district court judge said you can allege that there were falsehoods or that there was some reason to not believe these things. And all of that was knocked out in discovery. So there's simply nothing left of this case. So summary judgment was properly granted to all parties remaining in the case. We would ask that that judgment be affirmed. Thank you.
Thank you, counsel. Anything further, Mr. Jesser?
No, Your Honor.
All right, well, thanks to both counsel. The case is taken under advisement, and the court will be in recess.